So I'm going to start with our first panel and our newest faculty member. We are so grateful to have Margot Kaminski with us. She's going to launch her panel. Let's welcome Margot, affiliated faculty member, to the stage.
Should we follow?
Yeah, you guys follow.
We're getting settled. Is my mic's on? You all can hear me? No. My mic apparently is not working. Okay. Okay, now are we good in back? Still not good. I can talk very loudly. Okay, in the meantime, I'm going to get a chance to introduce our panelists. I'm really excited for this conversation and largely hope that it's going to be a real conversation, both between our panelists and with all of you. We are at a particularly exciting time for these two topics, for privacy and data security in the United States. And that is largely because of external pressures on the US regulatory system coming, as you all probably know, from the European Union, which in May had the General Data Protection Regulation, or GDPR, go into effect. So we will be talking about this concept of data as potentially the new oil or not the new oil, and the kinds of externalities that data do or don't throw off. But we will be doing that largely in the framework of discussing what's going to happen to US privacy law. And I have here some of the leading experts on exactly this question. So to my immediate left, I have Professor Daniel Massey, who is here at CU Boulder and is the Associate Director of Networking and Cybersecurity here. To his left, I have Andrea Matwyshyn, who is a Professor of Law at Northeastern University School of Law. There we go, and I'll stop yelling. The co-director of the Center for Law, Innovation, and Creativity there, and in 2014 was the Senior Policy Advisor / Academic in Residence at the Federal Trade Commission. To Andrea's left, we have Rob Sherman, who is the Deputy Chief Privacy Officer at Facebook, which some of you might have heard of. And to his left, we have Omer, who is the Vice President and Chief Knowledge Officer of the International Association for Privacy Professionals, which is the leading organization for practitioners in this area, and has been a source of enormous wealth of resources and professional support for privacy practitioners since this field started. Okay, so what I want to start with all of you, and I do want to keep this sort of informal and flowing, so please feel free to engage and jump over each other, and I'll intervene if that gets too heated. I want to start with this: data is or is not, data are or are not like oil. How useful is this framing, both in terms of what it communicates to the general public about the kinds of issues that we see in privacy and security, and what it fails to communicate to the general public and or to policymakers about the kinds of issues that arise? And if you feel free to use this as a gateway into talking about what you think the true harms are in this area.
Sure. So I'll jump in first. So I like the analogy. I think there's a lot to that. So I've recently been doing a lot of work in the automotive sector, where the idea that data is like oil is gaining a lot of traction. In fact, some of the large automakers, with the regulations in the EU, were actively pushing for, hey, you know what? The main revenue source of the vehicle might not be actually selling the car, but might actually be the data from the vehicle. And so in that sense, I very much agree with your analogy that data might be the new oil. The one part I think where that analogy falls a little short is that with oil, it tends to be a consumable, I own the oil, or you own the oil, or you've sold the oil to me. Data can have multiple owners, and I don't really have, the gallon that goes into my car ultimately gets consumed in my car. But for the data, that data might be mine and yours and NHTSA's and GM's and Facebook's and everybody else. So
the non-rivalrous nature of data for you is a distinction.
I think so. Yeah.
Andrea?
So I'm not a fan of the analogy for the sake of stimulating debate.
Cool.
Take the other side. I think what the analogy is getting at is that data is a high-value thing. And I would call it a thing of value in the contract law sense, in fact, which avoids the question of ownership entirely because there are copyright issues when we get into questions of ownership of consumer information, among other dignitary concerns. But I'd like to offer a different analogy, and footnote, no physical analogy will fit perfectly. But here's one that maybe fits slightly more aptly. The idea of data being like water, where there are variable qualities of it. It can be a necessary item, or it can be a source of devastation if it is, say, your house that is being flooded. It can poison you, or it can be a necessary sustaining input. Also, water has a history of triggering legislative intervention. So some of you may be from Ohio, or you may be old enough to remember the Cuyahoga River catching on fire multiple times. And that incident, or that series of incidents, because it didn't just catch on fire once, it had to catch on fire multiple times before we cared enough to do something. That incident led to CERCLA and led to a robust environmental law regime. So much like the river catching on fire, we're getting to a point in our information ecology where we're having concerns about the social externalities of information and whether the way that we've been managing it as a shared, quasi-shared resource has a need for a more constructive legal approach when harms happen as a result of the way that it is flowing.
Thank you. Rob?
Sure. So I generally don't like the oil is the new data is the new oil sort of framing, in part because of the issue that Daniel raised, which is that the data is non-rivalrous in a way that oil is not. I can give my name to everybody here on this panel. That doesn't take away from other people's ability to know it. That said, I think that the concept is. The thing that I like about data is the new oil is it is a catchy slogan that draws a lot of attention and causes people to think about the implications of data, think about how data should be regulated and those sorts of things. And I think we are short on ways to think about this concept and trigger the debate that we're having here today and that I think we need to have more broadly. If I think about sort of what data looks like, I don't have a catchy analogy like water, but if I think about what actually creates value in the data ecosystem, it is less the mere existence of data, right? Like we all remember the white pages sitting around that everybody leaves on their doorstep. Like information about people by itself is actually has very minimal value. It's fairly fungible. What has value is the innovation and analytics and technological development that's put on top of it. And so a lot of the reason why companies that use data are successful, whether that's Facebook or a startup in Boulder or in any kind of company that leverages data, is because they found some way to process data that creates value for somebody. And so the raw data itself is kind of like a raw material. It's like flour at a bakery. You wouldn't go to a fine bakery and pay a lot of money for flour. You would pay it for a baked good that has a recipe and a chef that's applied a lot of expertise in how to create it. So what does that mean? Well, I think it certainly doesn't mean that we shouldn't think about data as having value or think about data as something that needs to be governed. I think it's really important that we think through that. But I do think that means that the policy solutions that we bring to bear, which I'm not going to jump ahead to because I think that's where we'll go next. But the policy solutions that we bring to bear need to be different in the context of something that's not just about one entity having it and nobody else getting it, and where the real value comes from the work and the innovation and the advanced thinking that goes on top of it. And so I think that's what we need to grapple with as we think about what the right answer is to the policy question.
So I'll say first that I do revere The Economist, and I think it's The Economist that coined this phrase that data is the new oil. So, we have to pay our respects. Like Rob, I don't think data is like oil, and I'll say that fortunately, Unlike oil, data hasn't caused, anyone to dismember a person with a bone saw in a consulate because of a dispute about data, and I hope that's not going to happen. I think the question with respect to data and oil is whether data should be regulated as an asset, as a resource, and whether existing paradigms that exist in that space, like property law or antitrust law, should apply. So I see former Commissioner McSweeney here. I'm sure we'll hear more about this later, but I think we've started to see the beginning of a discussion of aggregation of data in the context of competition law and antitrust. It's come up in a couple of the recent merger cases in Europe, Facebook with WhatsApp and Microsoft, LinkedIn, and Apple, I think, Shazam. And it raises big questions. Does data create a barrier to entry for smaller competitors? Does it enable collusion between oligopolists? Or on the other hand, does it actually enhance efficiency and deliver incredible value to and benefits to consumers that otherwise wouldn't have existed if you think about search or social networking? Data creates externalities, and some of them are obviously negative. If you see the Equifax breach and others, and the risk of identity theft, or even broader risks to our democracy and political process, which we've been hearing about and handling. But at the same time, it also creates, again, incredible positive externalities with the ability to harness data for research and healthcare, or for sustainable development, or UN-type work to fight pandemics in Africa, or human trafficking and different causes like that. So I think there is a lot there in the question of whether data is an asset and what kind of asset it is and how it should be regulated.
Great. I think that transitions really nicely into the next thing I wanted to have us discuss, which is, so we've taken the idea of data as oil and unpacked that to say really what that's trying to get at is that data can be both an asset and a resource that could be protected in certain ways towards economic benefit or economic gain, and at the same time it throws off externalities that really prompt us to think about a governance model. So I want to talk about the latter of those two things, the externalities, a little bit more. We see a lot sort of in popular literature of conflation between privacy issues and security issues. And even the example that you just provided of harm is simultaneously a privacy issue and a security issue. So I'd love to have the panelists give their thoughts a little bit about where those two frameworks, first of all, what you think of, how you distinguish between those two frameworks when you're thinking about them, and where they overlap towards a common policy goal versus where they encounter in tension with each other.
Sure. So I'll start off again. So I think that is a fascinating question, and I think there's a good amount of overlap, but they are two distinct things. I think what we've seen, and I like the analogy of the flour and the bread, right? The issue for me is at what point do you need to make that flour available, and at what point does it reveal too much information, not in itself, but by being able to do the right analysis. So we struggled with this a lot in, prior to CU, I was running cybersecurity research at Homeland Security, and the privacy and the security were equally important, right? I want to make sure that the data is accurate. I want to make sure that the data is not manipulated. But the data itself can reveal tremendous information. One thing that's probably familiar to a lot of folks in the audience is, so we took data from a phone system, right? And we said, let's anonymize it. And we anonymized it by just scrambling the last 4 numbers. It took Steve Bellman at Columbia just a few minutes to de-anonymize the entire database, right? And come back and say, and so the real interesting thing is the connections between the data, the turning it from that flour into the bread. The way Steve did that is he said, you know what? There's probably as part of the panel, there might be some communication between Margot and Dan, and then Dan's probably talking, to his family, and this is his work, and once that thread starts to untangle, the whole bit of information occurs. And I'll point back to my other favorite example, and then I'll pass on to the next folks. So we have this in spades back in the automotive setting, right? Right now, we go in and we have our vehicles go through an emissions test. It's a complete waste of time in one sense, that my vehicle is tracking emissions data in real time, whether you know it or not. If you have a modern vehicle, your vehicle is reporting that back to the OEM in real time. I don't need to wait 5 years for you to take your car in to get an inspection. I can tell you right now if your car has an issue or not. And that data tells a lot about my behavior. That data tells a lot about what's going on. And there's at least maybe one major auto manufacturer where I'm not sure I would just take the data for granted. And so I think there's that interesting blurred line, and I'll pass it on to the next one.
So just to summarize that, as I understand that, you're saying that the security issue is the issue of trying to prevent access to or outward flow of the information. The privacy issue is more complex or more robust because you're actually now talking about even information that you've intentionally released can then lead to inferences of information that we think of as sensitive.
Exactly.
Okay.
Yeah.
So, for better or worse, I devoted 75 pages to this issue in an article called Cyber exclamation point. So for me, there's a pretty clean distinction, or we should strive for a clean distinction. Borrowing from computer science, the computer scientists who look at privacy issues are generally thinking about the ability of a particular individual human to be identified from things like traffic analysis. And so when we speak of privacy, we're talking about the contextually negotiated relationship between an individual human and a data collector, and whether the collection activity and use and repurposing map onto the expectations of that individual, whatever those may be. And those are driven by the negotiation, by the legal context, by a host of elements. And so we look to whether the system as operated by Alice conforms, and Alice's conduct conforms to what Bob and she agreed to. Security has a different unit of analysis. It's not the analysis of the individual consumer. Security is about the system. And so when we're doing a security inquiry, we're looking at whether Alice's system can successfully maintain the properties of confidentiality, integrity, and availability against attackers, including, say, Eve, a malicious attacker who wants to get all of the information and manipulate it or change it. Depends on the context that the attack is happening and whatever the motivations are. So it's not about the individual consumer. It's about whether a system successfully defends against third-party attackers. And so those questions, as a policy matter and as a legal matter, look different. They go to whether the system was maintained in a way that is appropriate for the business model. And that's where we start to connect up with things like fiduciary duties in the corporate law sense. We connect up with other types of imposed legal duties that may exist state by state. And so the unit of analysis is one of the most important differences across these two inquiries. And by keeping them separated, what you end up with is the policy ability to get win-wins on the security side in a way that you can't necessarily construct on the privacy side. So they don't always work in tandem as a legal and policy matter.
So just as an intervention there, that's fascinating. So what I'm hearing you saying, to project forward into the conversation we will have momentarily in terms of policy implications, is that both privacy and security are highly contextual, but they are contextual in the privacy sense to a relationship between individuals, or maybe an individual and a platform, and they're contextual in the security sense to a particular set of business practices.
To a particular set of technologies.
Technologies, okay.
Technologies, as those technologies should be managed in the opinion of the expert community that's building the standards for how those technologies should be built and maintained to defend successfully against attacks, against their confidentiality, integrity, and availability.
Great. Rob?
So I think this question about what these terms mean, what people mean when they talk about privacy and security is really important because, as you said, the solution set looks very different depending on what we're solving for. We've actually done some research where we've asked people, consumers, you're concerned about privacy, what does that mean to you? And it turns out that there's a huge variety of answers. Some people are concerned about who's going to see that there's the stuff that they're posting on Facebook. Some people are concerned about the government. Some people are concerned about their information being used for advertising. Some people are concerned about their information being disclosed to unauthorized parties. Some are concerned about hackers, and there's sort of this very broad range. And it turns out that the solutions that we as a company or we as a policy community apply to these things look very different depending on which of those things we're applying. And so one of the things that I always try to do in looking at these questions is to be very precise about what the harm is that we're trying to guard against, what the concern is, how we're driving that. And I think what that means from a legislative perspective, to go back, Margot, to your original, or to your introduction, is that legislation is going to have a number of different facets. There's not going to be just sort of one rule that's going to solve all this. All of that said, I mean, I generally agree with sort of the division that you're talking about. I see privacy and security in a lot of ways. And again, this is partially just my perception of what I mean by those words. But I think this is also broadly held amongst people who are talking about this. I see these two concepts as different sides of the same coin. If you think about privacy as the design of the way a system is supposed to work, right? So how information is collected, how it's going to be used, how it's going to be shared, these kinds of questions. And then looking at, I mean, I think your frame for sort of contextual expectations is a really interesting one for thinking about that. But I think about privacy as sort of that bundle of choices about how a system is designed to work. And security is often about whether there are unanticipated intrusions, whether information is being accessed or used in a way that's unintended and that's in violation of the design of the system. There's a lot more that goes into that. I'd also put individual security losses, so somebody's individual password gets compromised or something like that, into that bucket. But I think largely, I think we're saying similar things. The one angle that I would add to this discussion, though, is sometimes we use security not to mean information security, but to mean national security or public safety or something like that. And I think that's an area where there starts to become more tension. When you think about information security and data privacy, those often are very complementary, and in fact we've just changed our structure within Facebook so that the people who are responsible for those things sit in the same organization, because honoring people's expectations is in part about making sure our systems work in the way that they expect, and in part about making sure people can't get into them in unauthorized ways. But when you're talking about national security, then questions like encryption become really hard, because encryption has really significant value for privacy, and for protecting people's information against unauthorized access. But then there's a tension or some people would argue there's a tension in terms of, does that make it harder for the government to get access to information? And I think that's a real policy debate that we need to have.
Great. I'm glad you introduced the national security vector into the conversation as part of this. I also wanted to note, in response to Dan's comment earlier, it's very funny to me that it'd be surprising to the government that Steve Bellovin could re-identify people based on their networks, given the Section 215 program that Snowden revealed. But all right, Omer.
So very little to add here. I'll just say that for the first 10 or 15 years of my career in privacy, I had to constantly explain to people and justify the existence of privacy as something that's distinct from data security. And it would usually, the context is a cocktail party and somebody asks me, so what do you do actually? And I say privacy, and they say, so you mean data security? And I nod and continue walking. So that happened a lot. I think it's happening less and less now, because I think after the past couple of years and different stories in the press, people have come to appreciate and understand that these are distinct, separate areas, that security is about confidentiality and integrity and access to data. It's usually bipolar, it's open or closed access, no access. Privacy is much more nuanced and contextual and textured. It's about policy, it's about expectations and use of data, and is data used for purposes that people expect or find creepy. So those are, terms that don't even come up in the security discussion, but are very much the focus of what we do in privacy.
So I want to push back on a little bit this. So I largely agree, but the one thing I think we're giving a little bit of short shrift to is the true cybersecurity piece. So I think it's portrayed here. It's being portrayed a little more simplistically than it really is, right? So one way to look at privacy is, of course, classic CIA, confidentiality, integrity, availability, but that's been reworked, right? So nowadays, if you talk about cybersecurity, CIA remain, 3 of our core tenets, but we've added 3 other, critically important pieces, right? So one is systematic thinking, right? We have to be part about the bigger system, and I think we're oversimplifying a little bit too much if we say, it met the designer's expectations. Right now, our main problem is the designers often didn't have a security expectation, and we are discovering the security expectation as we find the vulnerability. To be like, oh, shoot, I didn't know my Nest thermostat could do that. I didn't know that my vehicle could, I didn't know my, so systematic thinking is a key part. Risk management is a key part. So we aren't going to protect. We are going to lose confidentiality, integrity, or availability. That's a given. If you have any cybersecurity person who says, I guarantee you any one of those 3, they are either they're intentionally lying or they don't know what they're doing. We've moved to this framework where the idea is identify, protect, right? But then detect, respond, recover, our good old NIST framework. And that detect, respond, recover becomes much more nuanced. And so I don't think we disagree as much, but I do want to, I do want to say that the security piece isn't quite as black and white as, I don't want the audience to think like, oh, we understand the security part, the privacy part's more nuanced. I think they're both pretty nuanced.
Yeah, can I just agree with that? And I'm not sure if I'm agreeing with you, disagreeing with me, am I disagreeing with myself? But I want to agree with the fact that even in security, these are blurry-edged concepts. And I think where we in privacy see it playing out now is in the angst that industry is feeling with the private cause of action and the CCPA, the California Consumer Privacy Act, which allows individuals to sue for data breaches, but there is a serious concern that the term data breach will be interpreted very broadly to basically cover any privacy infringement and not just a security breach, strictly stated.
So I'm absolutely itching to end up, totally. I'm itching to get into the actual weeds of the policy conversation in a minute. What I do want to do is identify that these commonly shared concerns over risk management and systematic thinking and nuance and sort of contextuality all point towards certain types of governance. And there, I agree, with Dan, we do end up seeing a lot of overlap, at least right now, between privacy governance and security governance in taking this risk management, sort of systemic build privacy into the company, build security into the company approach. And Andrea.
So just 2 quick points. I wanted to respond to Daniel's comment about the, how did you say, systemic thinking?
Oh, systemic thinking,
Okay.
yeah.
So I think for an average security professional, that's kind of built in at every stage. So your system, if you have not anticipated the evolving threats to integrity of your system on an ongoing basis, and you don't have a feedback loop and a good structure for patching things, and maybe a bug bounty program and a vulnerability management system, and you don't keep up on threat intelligence, then you don't have the ability to successfully defend, and therefore the property's not there. So when I was talking about the 3 prongs, I absolutely agree that it's all about a corporate governance system to maintain technical rigor in the properties of confidentiality, integrity, and availability. And I wanted to push back on Rob just a little bit. I agree that there are unique private sector and public sector concerns, but I think it's also important to recognize that there is a problem of reciprocal security vulnerability because the products that we use in the private sector are also used in the public sector. And what we see is that some of the most unfortunate public sector breaches sometimes result from private sector conduct. So as someone who was part of the OPM breach, for example, I worry about contractors. We've had other incidents where contractors have ended up disclosing sensitive information. And the products that we rely on, Microsoft Word, for example, might exist in a government agency that also engages in sensitive information processing. So the reciprocal security vulnerability crosses sectors. So sometimes we need to think about security not just in terms of which sector we're in or whether it's digital or physical, but as a whole across sectors and however information can be acquired. So for me, cybersecurity is just the internet part of information security because physical access to, say, a server is going to get you the information just as effectively, if not more effectively.
And one quick, I know you want to, but one quick addition to that. So I think we largely agree. I think one of the most interesting areas in both the privacy and the security is actually what we refer to now as cyber-physical systems, right? The convergence of the cyber and the physical world, and so it's blurred at some point. Is that so the physical properties, the cyber properties are now so intertwined on most systems that it's hard to disentangle them. And honestly, I think that's where a lot of the excitement is, and where a lot of the debate is. So if it's just data on my laptop or data on that's important. That's critical. I mean, there's a ton of interest in that, but it gets more worrisome as it's data on my fitness tracker or data on my medical device or data about my home network and also toward Rob's point, there's not that much exciting you're going to pull off of my fitness tracker. But as I think the audience probably knows, right, if I collect a lot of data from fitness trackers, and I can identify who those fitness trackers might be at, say, a base in Afghanistan, all of a sudden, I've created an issue where I can now map a military base fairly well off of data that by itself is the flower that's totally innocuous. But a symbol, right?
So one pushback on that, I actually had my information privacy class use substituting their student ID cards with a fitness tracker as an example for thinking through things. So they might push back against you on it's totally innocuous outside of the military context. But anyway, you all should feel, those who are here for my class should feel free to interview them.
Can I just address your data governance question?
No, because I'm actually about to frame it for everybody. You'll get a chance to do it in 1 second. Okay. So we have things that have been pulling out of the conversation so far. We have this idea that risk management is an appropriate tool, that contextual nature of harms is really key in both of these areas. And that governance and a view to sort of systemic understanding of how both companies and technologies work and what the design goals are, that has largely been the way that the US addresses these issues. And so I want to both ask all of the panelists, each of the panelists, what are the benefits of that approach? What is really gained out of that approach of looking at this as a governance issue, but also given the increased, especially European framing of privacy as an individual right, and given what Dan just brought up about cyber-physical systems and the fact that harms are now physical crashes as opposed to just information crashes, is compliance still the right framework? Now you can start, Omer.
Now I don't know if I want to touch it. It became really complicated. I'll say, a few things. So Helen Dixon, the Irish Data Protection Commissioner, recently said that the most important thing about GDPR, the European privacy regulation, is establishing and articulating the bedrock principle of accountability. And the principle isn't new. It's been there for 40 years, since the OECD privacy guidelines of 1980. But at least for privacy professionals, this is really what privacy in organizations is all about. It's the data governance mechanisms that ensure that the privacy principles are respected and maintained. It's the privacy impact assessments and the data inventory and privacy by design and by default and vendor management. It's all those things. So those are the tasks that privacy professionals take upon themselves and perform. And actually in the US, this profession and these best practices arose without regulatory or legislative mandate over the past few decades. In Europe, it's more on the books and hopefully increasingly on the ground. I'm not sure I addressed the question, but it was a complicated one.
Does that approach speak adequately to thoughts of privacy as an individual right? And does that approach adequately address, like a risk management, compliance-based approach, adequately address the kinds of threats that Dan raised about physical crashes as opposed to information crashes?
So, Margot, I might.
You're letting him get out of this.
What's that?
Okay. Sorry, go ahead.
So I might take. I may have heard something in the question that you didn't intend, but one sort of implication that I would take issue with is that there is an inherent tension between thinking of privacy as a fundamental right and thinking of privacy as a compliance or governance matter, because I think GDPR is a good example of where you actually have both, right? So if you accept that privacy is a value in and of itself that we need to preserve and that we all need to take action to preserve, then as Omer said, a big part of doing that is governance, is making sure that an organization understands what data it holds, understands how that data is being collected, how it's being used, how it's being processed, how it's deleting the information when it no longer needs it. All of those things are critically important to giving effect to privacy as a general right. I think from a compliance, so that's sort of like privacy as governance. I think there's a compliance aspect which is a little bit different, which I think is also valuable. Compliance is sort of you write in the law, and I think you alluded to sort of the California law as an example, but there are lots of examples of these where we have very specific obligations specified in law. And I think the value there is that people know, regardless of whether they're sharing information with a fitness tracker or with a car manufacturer or with a social network, that they're going to have some basic rights over their data. I think that's important, and I think that allows people to have confidence that their information is subject to minimum protections. It also gives organizations guidance about what they need to do. All of that said, I think if you just treat privacy as a compliance or governance matter, you're missing the fact that no law, no matter how well drafted, can anticipate every future situation. By definition, there's innovation going on, and data is being used in new ways. And so I think having principles that set the baseline, but also expecting organizations to act in the interest of the people whose data that they're collecting, and to think about these things is important as well. I'll give one example of this. You talked about design as sort of a systems design, but there's also an interface design component, right? So there's like, how do you communicate with people about how their data works? And a big part of the way that Margot set this up is talking about, and I think, Andrea, you sort of made this point too around expectations, right? Setting up, ensuring that people understand how their data is going to be used and that it's used in a way that's consistent with that understanding. And a lot of that is just something that you can't prescribe, and you have to think about in a very contextual, situation-specific way, and making sure that interfaces are designed in an appropriate way, people are being communicated with about their choices, and that choices are actually easy to make when we offer them. And I think those are important components too. Some of that goes to compliance and governance, but some of that just goes to broader sort of acting as an ethical actor and making sure that the choices that are being made are thoughtful and ethical ones.
If I can just offer a quick follow-up to that, I couldn't agree more with what Rob just said. And I would say at a higher level that privacy as a fundamental right isn't something that can or should be solved. It's not, it's a constant debate that, constantly morphs and changes, and we need to continue having it, but it can be managed. And the way to manage it is through these governance structures. So you're not going to reach a perfect state of privacy through good data governance, but you will manage privacy more wisely.
So I think that absolutely connects to what the GDPR does or is trying to do, especially as many U.S. persons looking at that regulation see the phrase fundamental rights and assume that it's fundamental rights like we have a First Amendment right to prevent the government from censoring us. And it's not the same thing. It's often a balancing test, and that balancing test is offloaded to companies to decide whether or not their own products meet that. In conversation with data protection authorities, in conversation with the European Court of Justice. But it's not an absolute right. So I think that absolutely describes GDPR. I'd be curious about how much that translates into the policy conversations we start having in the United States, where individual rights are conceived differently.
GDPR itself has twin purposes, and
Yep.
they are actually specified there. They're to protect privacy, but also to facilitate data flows. And so it could be
is
an
a trade
absolute
area. Yeah.
thing. And it has the legitimate interest clause, and it has a very broad research and scientific exemption. So it's definitely not, a unidirectional legal instrument.
So let me follow up on that. So one of the most interesting aspects from my perspective of GDPR is actually in the preamble. And so I'm going to pull this into the security side, since that's what I'm doing here. In the preamble, what GDPR stipulates is that there is an affirmative obligation to be familiar with the state of the art. And that demonstrates that a compliance mindset in security simply can't exist. It will never succeed. So going to the question of the compliance approach, while I'll leave it to my co-panelists to debate the viability of a compliance model for the privacy side, on the security side, it's a non-starter. And particularly when we look at the combined physical and digital systems, it goes beyond the availability concerns that a crash would have, right? Because the most devastating kind of attack would be my taking your, please,
Go for it,
if you
yeah.
have one, I have no actual knowledge of any particularized health concerns that you may or may not have. But for example, if you have an artificial pancreas, the most devastating kind of attack that I could carry out might be not to cause an availability failure, but to manipulate the data in the stream of your artificial pancreas feedback loop and to deleteriously impact your health over a prolonged period of time. Or say if I am an attacker sitting in a nuclear power plant and I'm on the payroll of a foreign government just hanging out, waiting to take down our power grid whenever they feel like it because we haven't secured basic things in our infrastructure. That would be an example where you have this compromise of access. So there's been a failure to preserve the integrity of the systems, but it hasn't resulted necessarily in visible consequences that a way that, say, an autonomous vehicle crash might be the default paradigm that we might think about a software failure. But the model of a visible, devastating car stopping to work or driving into something, that's only really 1/3 of the picture. So
Andrea, how does that translate for you into what companies should be doing?
So it goes back to my conversation previously. We start with the business model choice. What business are you in? How are you choosing to run that business? The same way that securities regulation and the SEC asks companies to do an assessment of what lines of business they're in, and then to disclose material information to consumers. That question is also the type of question that a company internally should be saying. Which systems are we choosing to build? How are we choosing to maintain these systems? What is the state-of-the-art knowledge about the vulnerabilities of these systems? Do we have a feedback loop in place where people have adequate authority to demand that these systems operate in a way that is safe for the public and for our shareholders and for our employees? And do we have a process so that when the state-of-the-art changes, we can stay abreast of it and hold ourselves accountable? And part of that model, for me, includes things like third-party audits with the same rigor that we apply to financial statements. Because unfortunately, we know that from history, when companies don't have third-party auditors, they're not always fully transparent and honest about the way they're managing their businesses. We're going through that kind of a phase with corporate security.
So what's interesting to me is that what you've just described actually maps very clearly for me onto a lot of what's being done in the privacy governance space. So it's interesting that you see that in contrast. So we have 10 minutes to solve the problem of US federal privacy law. I wanted to just start our 10 minutes with a 30-second description of some options we've been seeing. One option seems to be the contextual risk management option, which we've seen in a number of proposals, which largely tasks companies with a vague standard that says something along the lines of know your risk and manage it and give people rights that are proportionate to the risks that you see. Then there's a version that we've seen floating around that is more the data fiduciary or information fiduciary model, which is if you have a direct relationship with a consumer or a customer, this is more privacy than it is security. If you have that direct relationship, you owe certain obligations stemming out of that relationship, and those obligations track historic understandings of what a fiduciary is. There's another model that doesn't make it into the policy proposals, what we hear in the news all the time, which is the data as personal property, or as property, like IP-like property. And I'm sure you all have thoughts on that version. And then last but not least, there is more of a data protection FIPS model, Fair Information Practices model, which is somewhere between risk assessment and governance, and giving individuals concrete individual rights, like a right of access, a right of correction, and then also terrible news to American ears, potentially a right of deletion or erasure. So talk us through what you think is a good fit for the United States and why.
Well, so I would lean more toward your first one, the risk management approach, and a couple reasons. So one I'll take a strong stance against, which is data as personal property. I think some of the discussion we had earlier about how fungible the data is, how it's I love the flower analogy that it's difficult to say that's personal property because it blends into so many things. So I would prefer the least. The risk management makes the most sense because, and I'll tie back to one other thing on the other piece, which is I agree with you that I worry about compliance because I think, and it was touched on by both Omer and Rob, there's a potential conflict there with innovation. And if I'm too tight on compliance, then I'm not quite sure what I'm doing with this data yet or what this data is. And so to come in and say there's a strict compliance regulation. So I know it's not, it doesn't feel very firm, but the vague risk management to me feels right because it would best enable innovation. But I understand it's probably also least attractive from my personal point of view. It probably puts my data at the most risk. But that would be my take.
So sadly, I have no easy solution. I think that the way that the US moves forward in the short term is through a piecemeal approach where regulatory expertise is developed across agencies in their particular granted zones of authority. I think that there is a lot of opportunity for creative collaborations across agencies, in particular in one of my articles forthcoming. I advocate for a new technology practices bureau at the FTC, which is in line with proposals that commissioners have made, such as Commissioner McSweeney over there. My spin would be that it is composed of cross-detailed individuals from different agencies with additional authority, including finding authority, bolstering the ability to more effectively work across government agencies to attack the problems as they exist in the real market-driven economy rather than in compartmentalized agency approaches. And I'm particularly concerned about this, going back to the idea of digital hybrid physical systems and medical devices. So the next wave of devices in the IoT world is the Internet of Bodies, where we have not just Fitbits attached to the outside and medical devices inside, but things like digital pills, which may or may not be medical. British Airways, for example, patented a marketing-based digital pill. So when we start augmenting bodies, not all of those devices are going to fall under medical device regulation under the FDA's purview. So they'll go to the FTC primarily, which is what happened to the Fitbits. But having the kind of robust oversight that we might expect, especially on the security side, that's going to require more resources for that agency, and hopefully a collaboration not only on the federal level but also state law plays a role where we can nudge things like corporate fiduciary duties to reframe themselves to think more longitudinally about intangible assets, because part of the challenge is that fiduciary duties look at major transactions in the life of the company, but that's not how security and privacy work. The databases need to be maintained on an ongoing basis, and mistake at time one, even if it seems like a mundane detail, can be completely devastating at time two. So our traditional corporate law paradigms aren't quite a fit, and our contract law paradigms can evolve too on the state level. Some implied promises in every end user license agreement would go a tremendous way to helping with a floor of consumer protection. So all we need is some innovative states to lead the way.
Like, say, Colorado.
Yeah.
So, Rob, what do you think about implied promises to consumers in contracts as a matter of state law? No, I'm just kidding. What are your thoughts on the federal privacy landscape?
Putting the contract law questions aside for a second, I think it's I think we're still in the process of fleshing out what each of the proposals you talked about meant. There are some legislative proposals, but I think the meat is still being put on the bones, and I think that means it's too early to call winners and losers about sort of where the debate is going to go. That said, I think probably the right answer, if you can call it that based on what we know now, is a combination of the approaches that you talked about. I think when you look at sort of the whether it's the OECD or FIPS approach or GDPR, one of the things that I think is really valuable, and I said this before, is having a set of clear obligations that people can expect across the different types of entities with which they interact. That's also present in the California law, which Omer mentioned, where you have a right to know, you have a right to delete, those kinds of things. And I think giving people that clarity and giving organizations that clarity is important. Again, on the details matter, so on a right to delete, how to do that in a way that's consistent with the First Amendment is an incredibly important discussion to have. But again, I think if you stop there, then you're probably not doing all of the work. There are a set of baseline obligations that organizations need to undertake, and one of those is risk management. One of those should be to look at at foreseeable risks and understand how to guard against them. That's never going to be perfect, but I do think an important part of what we should expect from any organization that holds data is to undertake that effort. I think what all of these proposals have in common, though, is sort of moving beyond sort of the traditional view of privacy. And I think the FTC guidance has done this for a long time, but recognizing that sort of the old model of sort of notice and choice and saying, like, here's a privacy policy, click a button, and we're done, that just isn't going to work. That we need to recognize that privacy needs to be a much more intensive effort, both in terms of how we engage with consumers about their data, but also the efforts that organizations take on their own to protect data. I think it also recognizes that while there should be, like all of these approaches recognize that while there should be consistent obligations, not all data processing is created equal. I mean, we've talked a lot about contextual integrity, or the idea of context, recognizing that what people expect in one situation is different from what they might expect in a different situation, and if their information is used in new ways, that we have to think about that. Now, sometimes those additional uses have really significant value. Omer talked about those. Sometimes they have risks to people, and I think that's also a part of the bucket of things that we should talk about. In terms of what we should avoid and sort of what I would be worried about in the direction that things are going, one is vagueness. I think particularly when we think about concepts like data fiduciary, those mean very established things in the medical context or in the legal context when you're talking about the fiduciary duty that your lawyer has. I think it's clearly the case that organizations that hold people's information have obligations to uphold the trust that's being placed in them, but we don't exactly know quite yet what fiduciary duty means in the data context. I think when you look at Jack Balkin or Jonathan Zittrain, and when they talk about it, they also say that there's more work to be done to flesh out what that means. So I think, like, wherever we land, it needs to be clear what we're expecting of organizations. And then the other thing that I think is a challenge is fragmentation. I think most organizations, I think Facebook is included, are on board for really meaningful privacy constraints. But I think the challenge becomes if there's different privacy constraints in different places that amounts to a challenge in providing a service consistently across borders or in enabling people in one jurisdiction to communicate with people in another jurisdiction. That gets really challenging. And I think that's one reason why having the federal discussion is so important, is it allows us to get to a place where we have a single set of robust standards that people can expect and not get into the place where you have barriers to either offering services or communicating across the country or across the world.
I think where the discussion will be is not so much on the substance that you've alluded to, whether we call it FIPS or information fiduciaries, which, like Rob said, is an unsettled concept. It's more of a headline at this point. Strikingly, I find very little difference between the principles that are advocated by the privacy groups. Yesterday, there was a letter from 34 privacy groups, and we've seen one from EFF. And all the way on the other end of the spectrum, the Chamber, actually, and the Internet Association, the principles that they all espouse are very similar. I think where the battle lines will be drawn is around the periphery of these issues, and it will be around the degree of preemption, which I think is something Rob was hinting at. Obviously, industry wants preemption of California and, maybe all the rest, but that's a very big and contentious issue. The private cause of action and to what extent individuals will be able to sue under this federal law. The FTC rulemaking, will the FTC be able to finally promulgate rules, not just in data security, but in privacy, something that's been greatly curtailed by MagMoss 20 years ago. Covered industries and sectors, will this address all sectors, or again, will we see some industries being carved out? The question of harmonization of data breach laws. So currently we have 50 data breach laws in all US states, and industry wants to settle that in one fell swoop and sort of include it in the privacy, in the federal privacy legislation. And now in Senator Wyden's proposal, we've seen the idea of a very strict and severe, I would say, criminal sanctions on CEOs and chief privacy officers. And that's something that I've said makes the GDPR 4% of global turnover sanctions look quaint. I think that's a game changer, and if any, semblance of that makes it into U.S. privacy law, that will have profound impacts for all industries.
Thank you. We now have time for questions. Yes, and back. Dylan to your right, and then Dylan. Yes.
And both those concerns seem to be heavyweights on the scale when sort of weighed against other concerns of the industry, innovation or safety, what it may be. In a specific case with like autonomous vehicles, do you see, and in maybe other examples, where privacy is becoming outweighed by safety and where we really just don't care as much about the concerns of privacy?
Can I reframe your question just a touch?
Sure, yeah.
So the Consumer Product Safety Commission has started looking at digital safety issues in IoT devices. So your question is very well put in terms of highlighting the importance of safety. I think I would say that security is certainly part of the safety analysis, and privacy definitely can be. So it depends on how we frame the particular system and what the expectations are. But I would say that security and safety as legal categories are absolutely they must be harmonized. They can't exist free of each other.
Yeah, one thing I'd add is I mean, I think in some ways it's not right to say that privacy is by definition sectoral, right? I mean, we talked earlier about GDPR and sort of the rights and obligations that it creates. And I think a lot of these ideas about you should have access to the data that an organization has about you, should know what they're doing with it, those kinds of things. Those aren't things that are particularized to the automotive sector or the healthcare sector or to other sectors. And so I do think that those look different, right? The way that your car is going to communicate with you is different the way a website will communicate with you. But I do think we can find common ground in terms of the broad principles that should be applied. On the sort of like safety versus privacy versus security question, I mean, one of the things that I find encouraging about the debate that we're having broadly is I think we're starting to move beyond this idea that we have to choose. And what I'm about to say is easy to say and hard to do. I think we're moving beyond the idea that says, like, if we want safety, then we have to give up privacy. If we want beneficial services that leverage data, then we have to give up our privacy. If we want to have national security, then we have to give up on our information security, right? These are sort of these constructs that I think are just false, right? So I think it's an easy framework to say, like, we have to choose one over the other. I think the reality is, and Omer's comment about some of the new uses of data that are creating real value for society, I think are good cases for this point, that if we work hard to leverage privacy-preserving technologies like encryption, de-identification, and if we do that well, we can protect safety in the context of automotive, in the context of autonomous vehicles, for example, and make sure that people have access to safe and innovative autonomous vehicles as that comes to market, while also protecting their privacy. That definitely requires more work, but I think that's something we should aspire to.
Until selling their data becomes more lucrative than selling the vehicle. But I wanted to point out we have a very short amount of time left, so I'm going to try to call on 4 questions and then let our panelists respond. Sorry, Dan, to cut you off. No problem. Dylan, brief question.
Ooh, I hope I can cut this down then. My question is about incentives in a possible privacy or cybersecurity policy framework. What we've seen now is sort of a failure of incentives to make the business case for companies operating in the space to protect privacy or even protect at a baseline level security. And sorry, Rob, I'm going to pick on you a little bit here. Facebook's currently under a consent decree from the FTC. It's had multiple what are categorized as data breaches, but are really just instances of sharing data inappropriately. And that's not a mistake. That's got to be at some level intentional. What that means is that there's not either enforcement mechanisms or market mechanisms that are making it a good business case for Facebook to protect that information or to keep things private. So I'm curious about, from the panel, what would an effective incentive model look like? What kind of costs would we have to burden companies with to make them really take this issue seriously?
Beautiful. I have right up here in front with the...
Yeah, it actually matches pretty well with that question. What do you guys see as the right role of regulating effort and behavior of the companies and what they have to do? And what's the right role of punishing or regulating outcome, right? That if this outcome happens, the consequences are X.
Do you have any more questions from the audience? Gentleman in back there in gray.
I just wonder if the panelists have an opinion about blockchain technology and its potential as a model for personal data protection and privacy.
Blake Reed will be leading a panel on that in our next conference. That's entirely a joke. Okay, and then in the front here.
Yeah, you spoke earlier about the idea of privacy being this sort of contextual thing, where the legitimate expectations of privacy when a consumer has a relationship. But so many of the data processing and data transfer goes on without the knowledge, consent or knowledge or contractual buy-in of the people whose data is the subject of that action. So how does privacy as a contextual relationship work when there is no relationship or there is no contract?
Pick a question, any question, or all four.
Okay. Can I?
Yes.
Sorry. Okay. So I think what you highlighted is a deficit that law is suited to address, because a legal obligation is a contextual obligation. On the point of effort and sanction, So in the security context, when you're choosing to build a system a certain way, you should know every scrap of code that exists in that system because you're choosing those code bases and those libraries. And then you keep up with what the state of the art of knowledge is in terms of what can go wrong with those libraries. And so if you keep up with that and some new unforeseeable attack happens, that's a situation where you couldn't have anticipated that. That's a situation where a true unknown zero-day attack happens. I think it would be draconian to go for a liability finding in that kind of a circumstance. But where you have a failure of process and a failure of effort on the side of an entity, whether it's private or public sector, in terms of keeping control of the code bases that they choose to use and the hardware that they choose to put on their networks, that is a failure that is worthy of sanction, in my mind.
So let me add, I mostly agree with that, a few slight differences in that, right? So I think one challenge with I definitely agree with the idea that you need to sort of take due diligence and due care in implementing it, and there needs to be a sanction. If not, because otherwise market forces are a little slow to catch up with some of these things, whether it's security or privacy. I worry a little bit about the system. So one of the things in a lot of these cyber-physical systems, one of our biggest open challenges is to actually figure out what's in our code base. And so that, you know, and that is, so one example of working in a different sector, one of the, I won't name the sector, but so one group that was in a critical sector, their first cybersecurity problem that they wanted us to fund from Homeland Security was a tool that could let them know what's in the code base, because there are suppliers that are selling the same code to company X and company Y, and I've asked for options XYZ. It is on me to test that options XYZ work. What I don't realize is, Margot is selling that same system to Rob, and Rob asked for ABC instead of XYZ, and when Rob gets hacked, we go, I can't believe Rob had ABC, haha. It turns out I do too, I just didn't know it.
And this is why good corporate lawyers are a key asset for every enterprise that's data intensive.
Great,
I
you
love
just
that,
got
yeah.
jobs for every single one of my students. So I am being sanctioned for going over, but I want to give Omer and Rob each a chance to briefly respond to the comments if you have
Sure,
them.
I will do so very briefly since I don't want to be responsible for us running over. I do want to respond both to the sort of incentives and like what's the right role of the regulator, and also sort of the incentive for companies and like what do we need to do in order to get companies like Facebook to pay attention, which is, I know, not exactly how you phrased it, but I think it is a misreading. I think it's a misreading of the situation that Facebook finds itself in to say, like, if only we had bigger penalties or if only we had a bigger stick, then Facebook would have done something different. Because I think like the past 2018 in a lot of ways, and the challenges that Facebook has had, I think is a reflection of the fact that Facebook, it's not in Facebook's interest to have these situations happen. It's not good when people misuse our systems and either get unauthorized access or do things that are not permitted. That is bad for us. That's bad for consumers, and it's not something that we should want to happen or that we have any incentive to want to happen. And so I don't think that any amount of sort of increasing penalties or increasing the stick would change that. I think what our CEO has said is that in a lot of ways, part of what happened is sort of having an overly optimistic view of the way that people would use our systems. And I think when Facebook platform was created, a lot of that was because of the view that data portability and enabling competition was important, and enabling people to take their data with them was important. And so that was sort of the original motivation, and I think it was a really positive motivation. And I think what we've seen over the past 6 months particularly is a reflection of the fact that not just Facebook but companies in general, we're not the only company that has experienced data breaches in this period, that the work is never done to identify potential bad actors and bad and unintended uses and make sure that we're taking the steps that we need to guard against that. So what does that look like for us? I think it means taking steps to restrict access to data, and that third parties can get, and to engage in oversight. And I think that leads me also to sort of the question that you had asked about sort of what's the right role for a regulator. I mean, I think certainly regulators have a responsibility to take action when laws are violated, but I think another important part is sort of working together to help companies understand. And I think we've had this experience in our relationship with the FTC and others to help companies understand what's expected and to make sure that particularly as new situations come up where the law isn't exactly clear on a particular situation, to say, here's what we expect of you, and to work with companies to make sure that bad outcomes don't happen. And I don't mean to say that it's somebody else's fault when they do, but I think that a positive regulatory relationship is one that involves both working together to identify what the right outcome is, and then also taking enforcement action when it's warranted.
Thank you. Omer, you have negative 30 seconds.
I'm going to agree with Rob.
Okay, thank you. Please join me in thanking our panelists.
Very good meeting you.